coming back to this NCR thing, maybe. It has been noted that you have always insisted in NCR cases, okay, that be given to rightful owners, all right, based on Section 18 and not Section 6 of the Sarawak Land Ordinance. Why is that?
Thank you. That I can have this opportunity to explain further. Now, what happened is this: Section 6 of the Land Code allows the government to gazette an area of land to be given to a community or a village or a kampung, and they call it normally communal reserve land. Now, under that Section 6, that land could be a state land. It could be even a native customary land. It could be, I'm saying. But because it is created under Section 6, it is not automatically deemed to be a native customary land. Now, in my experience in dealing with these cases, all the cases where the land had already been gazetted as a communal land under Section 6, once the government get into that area to acquire rights, to extinguish the right, for public purpose, we call it, to be roads, for example, then the natives who work on that land, affected by the road, affected by the project, would not be able to be compensated their NCR land. They claim NCR, but the government says no, there is no NCR there. A very good classic case is Kakus. And I was there just before 2013 election. We went there, and I know for a fact that area had been given by the government in the 1960s. They moved there, the Kenya Padang, and they were given an area under Section 6 as well. And when the government constructed a road from the village to a logging road, about 18 kilometers, then they were asked to claim NCR. And that's the process. You must gazette, what do you call it, this a declaration that you want to take that land under Section 5, Clause 3 and 4 of the Land Code, and publish it in the newspaper. Then everybody would know that the government wants to take that for its purpose. So they fill in the form, call it Form E. And when the reply came, all were rejected. They said there was no such thing as NCR land. It's all state land. Now, I'm saying this because this is our experience. Then why, question that is this, why do you survey it under Section 6 when you can in fact right away survey it under Section 18? Because Section 18 is very clear. Where a claimant or a native had been living and residing on a piece of land for many years, and it amounts to ownership, that's the word used, amount to ownership. Of course, they must be there before 1958. Then he can ask for a title to be issued under Section 18. And that will be deemed a native customary land, and you don't need to pay any premium or rate whatsoever. It's free in perpetuity. Now, that is different from Section 6. Section 6 just a perimeter survey, they call it. And they give it under the name of the Kota Kampung, the headman of the village, which has no commercial value. But once you give it under Section 18, it is a title, a valid title, free of any rate assessment, perpetuity, forever. This person can go and charge it to the bank if he wants to. So that's the difference. So I'm saying, why would you waste your time and the money to survey it under Section 6? Might as well survey it immediately under Section 18.